Hi, David Campanile here, owner of Campanile Law, located in the great state of New Jersey. We do estate planning and we do probate. As always, if you would like to set up a strategy session with me on estate planning or probate, you have any questions, please feel free to reach out to me at njestateattorney.com. So this today's topic is about how to handle probate when there's no will. And it's kind of interesting, but let's just jump right into it. So I had a client come to me, kind of worried. There was no will. Spouse died, and she wasn't sure what to do. So kind of had to sit down and talk her through the process. So that's what brought me to you guys today. So what happens is when there's no will, the estate needs what we call an administrator, and basically the administrator is the same thing as an executor. So what happened in this scenario is the spouse, after 10 days of passing, 10 days of her husband's passing, would apply to the surrogates court of New Jersey, in the county in which her husband resided in at the time he passed, and request to be the administrator. Now, if it weren't a spouse, and let's say this person had no family, had no friends, had no kids, usually a friend, but the court can basically say, all right, everybody who's interested in being the administrator, give us a list. Come back and argue why you should be the administrator. And the court decides based on their presentation to the court and pick who the best administrator would be, or best person to do the job is. At that point, the court may sometimes, depending on the size of the estate, require the administrator to go get a bond to protect the estate if the administrator does something improper. So then what the administrator has to do is now go find all the debts. Actually, first, let's backtrack. Has to send out letters to potential beneficiaries saying, hey, so-and-so passed, you're a potential beneficiary, and notify any and all potential beneficiaries. Then the beneficiaries have to respond to the letter, and they can either waive a claim or see where they fall in the order. New Jersey has an intestacy statute that outlines the order in which a taker is given, a beneficiary would inherit. So then the court will find the closest individual to the person who passed away, and that will be the beneficiary. The administrator still has a job, though. The administrator now has to go find all the debts of the person that passed away. What do I mean by debts? Credit card bills, cell phone bills, mortgage statements, electric, water, gas, anything that the person could have owed money on. They have to basically send a letter out saying, hey, so-and-so passed away, I'm the administrator, here's my letter of administration. Please provide me with the final accounting of what is owed to you. And the debts have to be sent to the administrator or the attorney for the estate. And then the administrator will go to the court and say, here are all the debts that the person owes. Now, there are going to be more steps than that probably, because there could be people out in the woodwork. So you may even have to sometimes put a newspaper ad in and wait a little while. There's usually, in New Jersey, it's 6 months that a creditor has to report back that something's owed. And you're going to gather up all the debts, and in the process, you're going to gather up all the assets. The administrator would place the assets into a state bank account, and basically give an accounting to the judge, and give the accounting of all the debts. and say, Your Honor, we can pay off all the debts, or we can't pay off all the debts. Here's how much money we have, and then here's what the beneficiaries should receive at the end, or beneficiaries. So it is a little bit of a process. The only change between between having a will and not having a will really is you've appointed an executor in your will, whereas the court here is appointing an administrator, and it may not be someone that you feel comfortable with, but all the duties of the administrator are the same as an executor. So, and the other change is you name your beneficiaries in your will. Here, they're seeking out your beneficiaries if they're not known. If they are known, it becomes a little easier process. There you have it. That's basically probate when there is no will. And just a caveat, the probate process can take a short amount of time or a long amount of time. It's all dependent on your certain situation. So that is that. If you found this video informative, please hit the like button. If you are already not a fan of our YouTube page or a fan of our Facebook page, please like us, follow us, hit subscribe on YouTube. We're putting out content every day in regards to estate planning and probate. If you know somebody that's going through this process, the estate planning or probate process, that may have some questions, please feel free to share this video with them and tell them you were thinking about them. If you found this helpful, please share the video as well. As always, I'm David Campanile, owner of Campanile Law, located in the state of New Jersey. Have a great day.